Interesting question we're about to address. My husband is redeeding a property he inherited in California into a trust, naming only our 16-year-old daughter as beneficiary. If he passes, do I have any legal rights to that asset under the elective share you mentioned? More on that in just a second. I'm Valerie Zammitti of Zammitti Law. We're an estate planning practice in New York and New Jersey, and we provide peace of mind to families through our high client value services. If you are in need of assistance in establishing your plan or with administering an estate after the loss of a loved one, we'd be happy to help. You can reach out for a free consultation at yourplanningattorney.com. And we're always here educating, so ask questions and don't forget to share so we can help some folks together along the way. So this is a really important question. I'd like to caveat all of this by saying I'm not licensed in California, so I can't speak to the specifics there. And I'm not sure if this person who's a follower is a resident in California, didn't seem so, or here in New York or New Jersey. But regardless, this involves California property, and I am not licensed in California, so I can't speak to their laws. But when it comes to New York and New Jersey, I could talk about how these assets would be treated. For the most part, even inherited assets that you try to keep separate and or avoid your spouse from inheriting, they can become part of the elective share, which is normally on average about 1/3 of the estate assets and some of the assets that fall outside of the probate estate if they were like owned and controlled by the person who passed away. Now, that may not necessarily be true for a divorcing spouse and those assets that are held separately, so keep that in mind. But if you are married at the time of passing, filing for the elective share for assets owned by the decedent spouse is still possible. There are really only a few ways around this. One, there is a prenuptial or postnuptial agreement in place that excludes those assets. There's consent signed off on by you saying you do not plan to elect your spousal share relative to either those assets or all assets. And then some states may also accept certain types of irrevocable trusts for this purpose. So I don't know what kind of trust was being created in California, nor what California law would say, but you really should focus on whether or not it is irrevocable and if it meets the standards required to exclude it possibly from the spouse making that elective share later. For instance, the spouse who's trying to keep it out of the hands of yours, they essentially have to make it a complete gift. They can't maintain any rights, usage, or control of those assets, which is kind of uncommon, but possible. And I know to accomplish this and carve it out from the potential claim of a spouse at passing, it would be a little easier to do in New York State than over the border in New Jersey, based on what brief research I've done relative to this matter. So I know that those few circumstances, prenuptial, postnuptial, spousal consent, meaning you've signed off on it, or really all of those is signing off on it, or a particular type of irrevocable trust where the spouse doesn't retain any benefits or rights or control to that asset, and only if state law has fully allowed this. I think it's minimal and more of a case-by-case basis. So whatever state you live in, if your spouse has moved assets into a trust, seemingly to exclude you, get some legal guidance in your state to understand what that means for you. I hope that's helpful. Again, Valerie Zammitti of Zammitti Law. We're a practice in New York and New Jersey, helping families with estate planning and the administration following the loss of a loved one. If you do need some help, we'd be happy to give it to you. And we offer free consultations, which you can schedule at yourplanningattorney.com. Don't forget to share. And as always, take care. Bye-bye.